Hi everybody, Dr. Stringer, back at you from my office on campus. This week we're on to Module 7. We're talking about judges and juries. For those of you that haven't checked the syllabus, this is the last module before your midterm exam next week. So please be sure to make sure that you finish any module work, the review work that you haven't done. Maybe you want to go back and review your notes from the previous modules and things like that. There will also be a short review sheet that will release with your exam next week, so you'll have an opportunity to look at that to see what things you might want to study before you take your exam. So with that, just a short lecture this week as far as judges and juries, and then of course you guys can do your readings in your book, which I'm sure all of you are doing, and we can move on from there. So most of you probably are familiar with what a judge is. They're kind of the referees in the trial process, if you will. You have the defense attorney and the prosecutor who are kind of arguing different sides, and the judge gets to make the ultimate decisions on these matters. And they make rulings about appropriate conduct. They can declare mistrials, guide the questioning of witnesses with regard to the rules of procedure. They make rulings on what evidence will be allowed and what evidence will be excluded based upon the rules of evidence, which is set forth both at the federal level and within each state. They'll also oversee juries and rules on the case verdicts in the cases of bench trials. That's in cases where you don't have a jury which decides guilt or innocence. And then in most states, they'll actually be the person to do the sentencing. However, in some states, the jury actually decides what the person's sentence is going to be, as well as deciding guilt or innocence. I know Virginia is one of those states, and for that reason, that's one of the reasons why people tend to not want to have jury trials, because while the jury is less likely to convict you, they are more likely to give you more time. And also, while judges have the power to be able to suspend a portion of your sentence, juries generally do not have that ability to issue you a 1-year sentence and then suspend 6 months of it conditional on good behavior or something like that. That's something a judge could do, but not a juror. So, in the eyes of most people, the judge is a key player, but as I've kind of talked about, this is a little bit misleading. He clearly plays an important role, but he's kind of, I think I've talked about before, how with determinate sentencing and everything becoming so prolific in our society, a lot of the power that used to reside with the judge has actually gone to the prosecutor now. And so this kind of traditional view that the judge is the most powerful person in the courtroom is not quite as real as I guess people might think it is. As I've talked about before, the judges, the prosecutors, and the defense attorneys all comprise the kind of courtroom work group that we've talked about, which is based upon the courtroom communities theory. And then there's this kind of local legal culture, the shared understanding about how things should go. And this leads to kind of going rates for crimes and things like that. A lot of things, it's characterized, as I've said before, as by negotiation. Trials are not predictable and rarely occur. So there's not really any one method for selecting judges across the United States. At the federal level, they're all appointed by the president with the advice and consent of the Senate, obviously. But in the states, they can be either elected or appointed. And so it really depends upon the state. I know in Georgia, most of the judges are actually elected. Back where I'm from in Virginia, they're actually appointed by the governor. And then if you think about these smaller, municipal courts, like Marietta has a municipal court. These are small city courts. In those instances, the judges are appointed by the mayor. So if you think about this, one thing to think about that I always thought was pretty interesting is suppose you go to, just use Marietta Court as an example. You go to court and maybe you get a traffic ticket or something like that, or maybe you're caught speeding or something. So you're issued the ticket by the police officer, the City of Marietta police officer. The prosecutor also works for the City of Marietta, and the judge is appointed by the mayor of the City of Marietta. And so really the only person that doesn't work for the city there is you. So I like to think about it as like, well, are you really getting a neutral and arbiter of the law, when you're getting all of these people who are supposed to be interested in justice, who all have an interest, and a conflict of interest, I would argue, in seeing this case where you're convicted, and so politics can play a big role in these things as well. Not to say that judges are not objective, but they are humans, and they answer to the mayor, as does everyone else in that room except for you. So these are things to think about. So like I said, appointed by the governor usually, or election. The Missouri plan, in Missouri they have something interesting where there's a committee that nominates people to be selected, and then the governor appoints the person, and then later on they actually have an election for the public to see if the public agrees with this, and if not, then the person they'll have to find someone else. So this kind of uses a little bit of the benefits of both the appointment and the election. Personally, I kind of like the election a little bit better. I think that when you're appointed by the governor or the city or the mayor, I think that you're going to be more likely to answer to the mayor or the governor or whoever appoints you. And so that can, I think, with my Marietta Court example, create a little bit of a conflict of interest there versus if you're elected, then, you're probably going to be more likely to answer to the people who vote for you, right? To see if you're being fair. Diversity on the bench. So the typical judge is white, male, and middle-aged. That probably doesn't come to a big surprise. Political party affiliation of judges matches that of the president who appoints them, or usually the governor or the mayor, whoever appoints them. And so, for the most part, though, from what I've seen, judges tend to be a lot of times fairly conservative, fairly tough on crime, because that's just a political stance. I mean, even today, liberals cannot really be seen as not being tough on crime, and that's a whole nother lecture to go into nowadays. But that started with presidential elections years ago, and the tough on crime movement, and the war on crime with Nixon and all these other things. And we can talk about Bill Clinton and how he wasn't really that tough on crime, but then he suffered political attack, and so then he had to get tough on crime. And all the other issues with Bill Clinton as well, which are not really that relevant. But anyway, so these are all things to think about. But getting black judges and women judges can actually make a difference, because they have experiences and attitudes and beliefs that are a little bit different than those of male, middle-aged white men. So these are all things to think about. You do have a Sixth Amendment right to a jury trial. One of the things that a lot of people don't know is you have a right to a jury trial, but you don't have a right to a bench trial. There's nowhere in the Constitution that says that. And so, in an instance where you might want to have a bench trial, like, that if the jury convicts you, they're going to sentence you to 50 years in jail if you're in a state like Virginia where the jury gets to make that decision. Well, guess what? If the prosecution decides that they want to have a jury trial, then you're having a jury trial. For those of you that don't know, there's a difference between a jury trial where guilt or innocence is judged by the jury. You guys probably know what a jury is, right? It's your peers, and people are brought in based upon a process of voir dire, which I'll talk about in a minute. And then there's the bench trial, where you don't have a jury, and the The judge would just decide whether you're guilty or innocent and then impose a sentence. So you do have a right to a jury trial. You do not have a right to a bench trial. So if you decide you want a bench trial, you may get it, you might not. It would depend on the prosecutor. Again, the prosecutor wields a lot of power in the courtroom. So the voir dire process, which I was talking about, is the process in which we select jurors in the United States. And so what happens is we have a poll and we call in people for jury duty. Some of you have probably been called in at some point in time or will in the near future. There's some disqualifiers, like if you're a felon and things like that. And then the lawyers will be allowed to ask you questions to see if maybe you have any biases. And so if you do reveal that maybe you're a member of the KKK or something like that, then the defense or the prosecution would be able to challenge for cause you're being included in that jury, and they say thank you for coming, juror number 6, but based upon your admission that you are a member of the KKK, we do not believe that you would be able to be a fair juror and objectively decide this case. Just using this as an example, obviously there's multiple other challenges that could be made, and then you also would have your peremptory challenges. So a peremptory challenge, you don't have to give any reason for wanting to exclude the juror. You can just say, thank you, I'd like to excuse juror number 6, and I'm using one of my peremptory challenges. Now, the thing to think about with peremptory challenges is you don't get an unlimited amount of these. Challenges for cause, you get an unlimited amount of it. Either the prosecution or the defense attorney can challenge any juror for cause, and they can do it for each and every juror or none of them. It's up to them. But peremptory challenges, you usually get a limited amount of them. Usually the prosecution will get about 3, and then the defense will get about 6. And so they give them a different amount of peremptory challenges. Of course, this varies across states and things like that too. And there's been a little bit of research, especially in the southern states, about attorneys and prosecutors having a little bit of racial bias when using their peremptory challenges. Maybe they excluded all the white people, or excluded all the African American people, or something like that. Excluded all the women, or excluded all the men, things like that. And so those can be. There have been cases where they've actually been able to prove that this actually occurred, and then if they can prove that, then you can have a mistrial declared. But it is kind of challenging to be able to prove that. So the jury pool has to be a random cross-section of the community. So the jury pool from which you select the jurors has to be representative of the community. And this is not to say that the people who actually get on the jury are representative. Because of this voir dire process that occurs, you may or may not end up with an actual representation of the community, but that's not guaranteed to you on your Sixth Amendment. Court cases regarding jury selection have involved the question of racial discrimination, as I already said, and then there's also been juror dishonesty. A juror could lie. They could be a member of the KKK and they'd not tell you that. There has been issues where that's been raised in the past, and they're not supposed to lie. They are under oath, but it's very difficult to detect these things. So there's been a little bit of research on jury decision making and what influences juries' decisions. And there's procedural characteristics, the juror characteristics, and then the case characteristics. Then the deliberation characteristics can also matter too. And so here's just an interesting illustration of what I like to call the CSI effect. And so this is, the number of the jurors that would be willing to convict somebody and expect that you present some sort of scientific evidence. And if you'll see, that this varies a little bit across different types of crimes, but in crimes that involve a gun, perhaps, you would expect to see some DNA evidence. Over 75, almost 80% of people in the case of a gun want to see some sort of, different types of, that was ballistics evidence. DNA evidence in a rape case is upwards of 70%, as well as some kind of scientific evidence. And so this is an interesting issue when it comes to juries, because many juries nowadays are expecting to see this stuff because they watch CSI, and in every case, CSI has some sort of evidence, right? Some sort of cool scientific evidence. But that's not always the case in the real world. But too many people have been seeing that show, or at least that's the argument of the CSI effect, that now they're less likely to convict people if the prosecution does not present this type of evidence. And so, this is an issue to think about when we talk about juries. Then there's also finally the issue of jury nullification. Okay, and so this is when the jury just decides that they're not going to find the person guilty, even though there's overwhelming evidence that the defendant is guilty. And so in this case, the jury ignores or nullifies the law. And so, there's been cases in the past, particularly in the South, where you might have all white juries that, find that a white defendant who injured or committed a crime against a black person was not guilty. This is not right, and they're clearly nullifying the law because the law says that the person should be guilty, but there's that racial issue that goes into it, and then they're nullifying the law. And then, of course, there can be other issues in it too. It's not always related to race. Sometimes you have just issues where the defense has put on such a good argument that they really feel sorry for the defendant. There could be a case where there's a man who beats his wife every day, and so eventually the wife shoots and kills him. And under self-defense, it would have to be an imminent threat that he was literally in the case of, or in the process of beating her when she shot him. But if you could make the argument and then make the jury be sympathetic, then they might be willing to acquit that woman based upon just the fact that she's been beaten for many, many years, even though legally she would still be guilty of murdering him if he was sitting on the couch watching the TV at the time. And so that would be another instance where jury nullification could be an issue. So it's pretty much just acquitting someone whenever the evidence supports a conviction. And so that's the last thing that I will talk to you all about. And I hope you guys will read your chapter, especially since we have a test coming up next week, and maybe even read those additional readings in there too. And please don't forget to do your discussion boards and your weekly quizzes too, because those are a part of your grades. And so with that, I hope that everyone does well on the exam, and I wish you all good luck.